CPI report, Child Protection in Iowa, is brought to you by Vocal Victims of Child Abuse Laws. You can you can see the program on Sunday afternoon at 1 o'clock and again Wednesday evening at 9:30, all on Mediacom Cable Channel 15. This is our email, vocaliowa@mchsi.com. We also take phone calls from parents. We try to help parents on a one-to-one basis. We're not attorneys. My number is 515-276-3956, and John's number is 515-282-2672. My name is Don Burgmaier, and at the controls is my co-host,
John Harvey, and welcome to the CPI report. That's Child Protection in Iowa. And there's a number of things that we do, but there's two major things. One is to influence public policy, and secondly is to assist people on a one-to-one basis who are having difficulties with the Department of Human Services. And there are a few of those sort of people around.
quite a few.
Right. And we're going to be talking a little bit about what kind of advice, since we're not lawyers, we can only hand to you the information that we know from public sources and from experience that we've had working with people. So we can't give you legal advice as an attorney can, but we can give you what we believe to be information that could be helpful to you. One of the things we mentioned calls from in central Iowa, but there are other people, and you might want to pull out some information, Don, from the Ottumwa area, where if you're in the Ottumwa area, you can reach folks that have same kind of concerns that we have here with at Vocal, and it makes very little difference. Whether you go to someone who works with Vocal or someone who works with a group like Vocal, because we operate off the same kind of documentation. So you can contact Linda Downs if you're in the Ottumwa area, and she can give you assistance in the same fashion that we would give you assistance. She's not an attorney. And sometimes people are desperate and need help, and sometimes we feel that maybe the attorneys aren't the right ones to go to. Sometimes you can battle these cases out yourself if you have the right kind of information and you have some kind of an idea about how to accomplish that.
I
Okay,
wanted to point
Don?
out, John, that you want to back up there?
Yeah.
The website here for information.
Stay
on
with your
her
mic. Stay with your
group.
mic.
And also down below here, CPS Watch, that's another organization, but there's a tremendous amount of information for parents that you need to go into these websites to get a lot of information to help you fight the case, to understand what you're up against with DHS, because this is a battle that you're in. They want to steal your children forever. John?
It's interesting because not always do you get return calls. That is, calls that say, well, you've been very helpful on your program. But I've gotten 2 or 3 of these in the past 3 or 4 days. And one of them was a father who said that he'd been watching our program and that he was very much interested in what was going on because they had taken his little boy. And he said, I paid attention to what you said. I did what you suggested, and now my little boy is with me. And I think that's terrific. I had one fellow even in one of the New England states that called me. How he ever got a hold of my name, I don't know. But I gave him a few ideas about what he should do. And I said he certainly needs that little boy in his immediate circle, so that he can have contact with him. And you see, a lot of these things are important to individuals, fathers and mothers, but I tell them don't plead that part of the case, that you have a right to do this or you have the right to do that. Simply tell them that your child has a right to see you, and that's part of the package of rights that the child has, is that he has the right to maximize his contact with his natural parents. And anyone who steps between that should get a warning and should step aside, because that's extremely important. Well, Don, we're going to spend a few minutes before we turn to Terrance. We're going to have a little bit of discussion here about what you should do when the knock comes on the door, and what you should do with the report that you get from the social worker. So I'll turn that matter over to Don. We'll discuss that a little bit.
Okay, I'm going to take 1 minute, hopefully, and show you on this chart what some of the steps are that is ahead of you when the social worker comes knocking at the door. She wants to write up an abuse report on you. And your second reaction after you get the abuse report is to resist that report. And so that takes you into making a request for an evidentiary hearing. In Des Moines, it's at the Lucas Building. You can have it in any area of Iowa, but if you're around Des Moines, you'll probably come directly into the Lucas Building. And then whoever loses that hearing then has an opportunity to appeal the decision after the ALJ makes a proposed decision. And then the next step is, if whoever doesn't like the decision, you can go to the district court. And then the final step is an appeal to the Iowa Supreme Court. And there's 2 or 3 steps there. First, they'll put you in the Court of Appeals, and whoever doesn't like the ruling can go on into the Supreme Court. So that gives you an idea of the court battle you got ahead of you. Now, back to the knock at the door. First thing is, you don't want to talk to that social worker. You don't want to admit to her that you have nothing to hide. Well, you may be the most honest person in the world, and you have not abused your children in any way, but the social worker wanting to write up an abuse report will turn your words around and go ahead and write that up if she wants to. So first thing is, don't react and start talking. That's the worst thing you can do for yourself, because then you're going to have to fight your own words later on to clear yourself on this situation. So you don't want to dig your rut any deeper at this point in time. And I suggest you call Vocal for more tips along that line.
Or if you're in the Ottumwa area, call Linda Downs.
Correct. Yeah, get some assistance from other people that have went there before you. Now, let's assume that the social worker has already went so far as to write up in a report, and she lost my train of thought. Founds the report, and then she sends a letter out to you saying it's a founded report. One, you want to make a request for that report so you know what's in it. You don't want to put your head in the sand like they say the ostrich does. He doesn't do that, I understand, but that's the old saying. You don't want to do that. You want to get the information. And you want to continue to get information from DHS, because ignorance will destroy you. So you make that request for the abuse report so you know what's in it. And there should be probably directions in the paper that you get from the social worker. And then, because it's a founded report, you want to get that expunged. That means to totally destroy it. That's like hitting the delete key on the computer, but it's goes far deeper than just hitting a delete key. You want it cleared from your record. So you make a request for expungement. And how do you do that? Well, the people that are watching our program can do it on the internet. John, you want to switch over to that information? And the person in charge of that at the Hoover Building is Rhoda Harris. And her job is to line up or set up the hearing for you that's going to be held at the Lucas Building. And she is also, at least at times, using her new talent of going over and representing the DHS, although she's not an attorney. So she's doing two things. She's running an office of setting up the hearings, and then she turns around and fights against you at the hearing and says you don't deserve a hearing. So that's something you're up against there. There's a lot of things that it's too bad parents don't know in the beginning when they receive that child abuse report. There's so many things involved in this situation to destroy the family. So as a result of that, well, why don't you back up, because we didn't talk about what down here at the bottom.
Give us your mic.
DHS has a website that you can go to, and that's their website, or the shortened version will take you to the same place, snipeural.com/9FAR. You type those words into Google, snipeural.com/9FAR, and it'll bring you up to the website that DHS has. And now I'll put this on here, and it'll take you to this form. One-page form, appeal and request for hearing, to be filled in by the parent that's got this abuse report. Over on the right-hand side, you'll probably want to check the other box down below. I'm surprised that they don't have a special box for child abuse reports, because there's getting to be a lot of those, but they try to discourage people from filing the appeals. Anyway, you fill out your name and address, your phone number, your county. Most people can do that without help. And ask for an interpreter. Well, if you're speak English and you understand it, that does not apply to you, or you'll say no. And then down below, provide a brief bit of information about the case, and say make a comment that the abuse report is wrong, and then it says I appeal and request a hearing, and you sign your name, or you type your name in this case on the computer, and your date. And down there it says pre-hearing. Do you want a pre-hearing? Yes or no? Well, in my opinion, it's very important. So if I were you, I would put yes then. It don't make any difference if you've had experience or no experience. You can learn a lot through a pre-hearing prior to going into the hearing. Once you get into the hearing, it's almost too late to learn how to respond in a hearing in front of the ALJ. The DHS attorney or whoever is representing the DHS, they have their tricks on how to confuse you and change the outcome of that ruling just by their talk. The first time I went through, Mary Kay Wickman was the attorney, and she took up the whole time saying...
Smart lady.
let's see, which attorney did I tell you that?
Mary Kay Wickman.
Oh, well, I actually
Smart
meant...
lady. Almost as smart as Hillary.
Mary, let's see, what's the other attorney's name? Mary Kay, there was another similar to that. Sorry, I forgot your name. Anyway, she she took the whole time telling me the Iowa code. She said,
You
"Do you
couldn't forget
understand
K.
it?"
Miller Todd's name, could you?
Oh, was that it? Yes, I think you're right. I knew there was a K in it. Mary K.
Oh.
Miller Todd.
Hmm.
K. Miller Todd. Yeah, it's been a while since I've resisted her. Anyway, as she was an attorney in my case, so she says, "Don, do you understand what you're doing here in the aisle of the rules, the law? Well, I'll explain it to you." And so that was the whole hearing. She was sat there on tape explaining the whole thing, and then the judge ruled in her favor. I don't remember what the outcome was exactly, but at that point it was against me, and I had to appeal to the Supreme Court. And I think on that issue I won, but I can't remember exactly what the deal was. But she just took up all the time quoting law and explaining it. Well, that's nice to explain it, but that's not what what a hearing is about. A hearing is to provide evidence to the court, both sides, to get the ALJ to make a decision based on that.
Not on a pre-hearing. That's all. Pre-hearing
Well, this is a regular hearing. She
Yeah.
did it in.
Okay.
She spent an hour doing that.
Telling
took
you
up
how to do
the
it.
time. Yeah, and that was. And then the judge made a ruling based on that. Well, you see, I didn't get an opportunity to provide my side of the story. What a flimsy way to do it! And judge makes a ruling based on her quoting law. Well, anyway, so that's the way that goes. So you want to bring in witnesses to your hearing. So you prepare through the pre-hearing, and you let them know that you're going to bring witnesses. And I would tell them in advance that you want to have at least 2 hours for each witness, because they like to give you 15 minutes and have a break and send the worker home, and you come back after break and ready to ask more questions, and you'll say, "Well, where's my witness?" "Oh, she's done. We sent her home." So you get another witness up there. Go for another few minutes and then get another break, and they'll send her home, and you don't know it because it's already pre-planned that they'll give them a certain amount of time and send them home, and you have no witness to question when you thought you did. And wow, they'll make you think that you're accomplishing things. But if you push, you might win the case. If you don't push, you'll lose. So after that hearing, where you just sit around the table and talk, and the ALJ asks questions, and you give your information, then there's a proposed decision, and if you don't like the proposed decision, or the state doesn't like it, then the state can appeal back to themselves. Don't you like that, where they have total control of the whole situation? If they don't like the outcome of the ALJ, then they can appeal back to themselves, and then they can change the whole picture and keep it under their control. But then after that, then you have an opportunity to go into district court, where you can hopefully change the picture. But by that time, DHS has convinced the court you're a child abuser. So it's an uphill battle. But if you keep fighting, there's a good chance you'll win. Like I say, if you don't fight, you'll lose. So, John, you got a comment?
Okay. There's a couple of references in statute that you probably should read, and they'll some of your paperwork will show you the statutes upon which they are basing their claims. And one of those is 235A. That's 235A point 19. You should read that pretty carefully when it comes time to appealing your decision. Also, look at Chapter 17A of the code, and that'll give you a pretty good idea about how the evidentiary hearing is to be conducted. Seldom ever do they go by the rules, but you have a right in your appeal, and we showed that in Mock versus DHS. You have a right to discuss every issue that is involved in your appeal. So they can talk over you, they can do all kinds of things, but you can assert in the record, and that's either when they're taking a record on audio tape or when they're recording it in some other fashion, you have the right on tape to object to what they're doing. In other words, it isn't, and you don't object because you don't like what they're doing. You object because what they're doing is not correct with respect to the statute. You have a right to discuss every issue, and the case of Mock versus Department of Human Services illustrates that. And it's very important that you give close attention to these issues, because if you don't, this thing can hang like the old albatross around your neck for a lifetime, and can not only disturb you but disturb your children, because you see, if your children were victims of child abuse, then they presume that they will be victimizers when they become parents. So an abused child becomes an abused parent by and by. That's the way they do business. Well, we have had the luxury of having some commentary from the courthouse. Commentary from the courthouse is very much appreciated around here, because anything we can learn about how courthouses do business, about how judges do business, it's important that we know some of the trickeries. We know how to avoid some of the pitfalls that the legal profession, these so-called individuals who have a tendency to want to control things, do business. Well, we may not be able to control the judges, but you can always make a note in the record, and that record is extremely important. And if there's something that is incorrect about the way they're conducting business, whether it's in a domestic abuse case, or whether it's in child abuse case, or whether it's in juvenile court, where they're trying to remove your children from the home, if what they're doing is incorrect, now this doesn't mean something that you disagree with. There's a difference there. Sometimes the officials can act in a fashion that you don't like, but if it's correct, there's very little that you can do about it. But you can raise an objection if what they're doing is not in keeping with the law. And you can hold their nose to the grindstone on with respect to the law. Well, let's take a walk over to the office of Terrance Walker and see what he has to say about what is happening on the court scene this week.
Good thing it's air conditioning as we walk
Yeah,
across.
you almost called me Clarence.
Clarence Walker.
One of the things I was going to say, thanks for introducing me, John. Thanks for having me on the show, John and Don. I am the self-appointed, or should I say God-appointed, judge of the judges here in Iowa. Somebody has to do it. It might as well be me.
Do you have half your brain tied behind you just to make it fair?
Well, I don't have those sort of limitations that the other judges do. So, yeah, no strings attached, no weird stuff like that. One of the things I wanted to discuss, it's funny that you said Clarence, called me Clarence anyway, but one of the things I did want to discuss was Clarence Thomas, the sole black jurist on the Supreme Court of the United States here in the United States. One of the recent cases involving a criminal trial in which a guy had several of the jurors removed from his court case before they were impaneled and sworn in. Several of the jurors were actually black. Well, in a 1986 case involving Kentucky versus Bastion, I believe, the United States Supreme Court said that the prosecutors cannot do that without having a reason for doing so. Well, it struck odd to me just last week. Clarence Thomas was the only judge on the United States Supreme Court that couldn't see that what the guy had happened in his trial was undoubtedly racist. And it's a sad day in America. You know, we had one judge on the United States Supreme Court that was black before, Thurgood Marshall, who was a champion for civil rights. It just pains me, and it should pain everyone, some 30 years later or 20 years later. I think he died in, what, the 80s, was it? Or he's removed from, or he retired from the bench in the 80s. Some 20 years later, we have a guy who experienced racism, who was a part of affirmative action. He benefited from affirmative action in school he went to, who all of a sudden is now against affirmative action, but then all of a sudden he can't see racism. But, you know, this is the kind of mental illness that we've got going on. And I do say mental illness. One of our colleagues here, Julie Alexander out in Las Vegas, Nevada, who's spearheading a couple of organizations out there, talks about this quite a bit. How a lot of the judges that we have that are in power are somewhat mentally disturbed. And that holds true for not only the Supreme Court of the United States, but the Supreme Court of the state of Iowa. Now, I wanted to go through a couple of the rules of conduct here for the judges that are supposed to be followed. Judges are required to follow these so-called high ethical standards. One of these is, they're called canons. One of these canons, Canon 1, there's like 7 of them altogether, says a judge should uphold the integrity and independence of the judiciary. 2 says a judge should avoid impropriety and the appearance of impropriety in all activities. The rest are more so like you should stay out of political matters and should perform the duties of the office impartially and diligently. All of these things are really quite vague. And I think they do this on purpose because when we file a complaint against a judge, it goes to a Judicial Qualifications Commission here in Iowa, which has as part of its membership not only a lawyer, but I think also a judge and one layperson, one person that's not either. So, you know, but in either case, the citizen that's not a lawyer or is not a member of the bar is a minority, which, you know, I feel it should be the opposite. Now, we don't have anything that interprets these canons. We don't have we don't have a lot of decisions coming down from any of the courts spelling out what exactly is a violation of these canons. But yet, we as citizens are supposed to be able to complain to the Judicial Qualifications Commission when a judge violates these canons. And I think it's a joke. Why? Because we have so few judges. Since the Judicial Qualifications Commission has been in place, it has removed less than, I think, 5 judges, or is it 4 judges in almost 40 years? What a joke, you know. I'm sure that there's a lot of cases, I've seen plenty, where judges have done unethical things. And, you know, they may be loosely interpreting these canons. I think they need to add some more canons or clarify these canons so we can know exactly what is a violation of them. You know, we can say if there was a law to be passed, we as citizens, we should have some integrity, and we have no cases interpreting what is integrity, no specific guidelines for what is not holding out to be having integrity, then, you know, there's obviously going to be no enforcement mechanism. There's no enforcement mechanism on either of these two, obviously, because, you know, for one, do we think one example I could cite is was the judge of the Supreme Court, Lavarado, is he being true to the standards of integrity when in January and February he's saying that the state needs more money, to give more money to the judiciary because it's overwhelmed with all these different things, and we need more court staff, we need more of this. And then when they give him the money, he lobbies and gets pay raises. You know, is that having integrity? I think that's called a bait and switch. And if any hustler off the street was selling you something and told you what you was going to get and was this, and he gave you something else, that would be a crime. Well, what Chief Judge Lavarado did, in my opinion, is a crime. And he is not holding up to his standards of integrity, and having all of us pay the judiciary over $12 million this year when he asked for $7.6 million, and he said nothing about pay raises at first. That's just my 2 cents on that whole matter.
Okay.
But since we have a Judicial Qualification Commission that is basically ineffective and is headed by people that are members of the bar and attorneys, we will have probably nothing done by that same commission when it hears this matter. Did you have a comment on this, Don?
Yeah, John, do you want to zero in on this here?
Are you talking about these other cannons? Well, I don't think these cannons, you know, they basically are kind of flimsy. You know, compensation received for quasi-judicial
What do you, that practice,
matters.
A judge should not practice law after assuming
Stay with the
judicial duties. You got a comment on that? You want to swing that a little bit?
Well, I think that we should have the judicial qualification comment on that, because they really are not clear as to what this junk means. You know, what do you mean after a judge should not practice law after assuming judicial duties?
I thought he had closed down his office, attorney office.
Maybe that's what that means. Maybe it should not offer, or you know, not be in practice at a time. I think magistrates are allowed to do that. They're allowed to practice law and be magistrates at the same
The
time.
Chief Justice of the Iowa Supreme Court years ago, Art McGivern, he was out of Ottumwa, I believe it was, and he had an office when he was not here in session in Des Moines. He had an office out there, and I've heard other judges do that, and I've never understood that canon that we just read, and how they can do that.
Well, it's probably because they're in cahoots with each other. So, I mean, when, you know how the old phrase goes, one hand washes the other. Well, when you have a situation where your cohorts are in a position to critique your behavior and handle the complaints against you, it's quite obvious to me that you're not going to have a whole lot of results from any resulting penalties from their complaints on their behavior.
I ran into one case where a 16-year-old girl was on a China petition, and and her judge was the family's attorney for an 18-year-old who had intercourse with a 16-year-old. Well, of course, that's a violation of the law, and
Total conflict of interest.
but he turned the conflict into an agreement. You know,
A money-making deal.
The deal was the boy wasn't charged. He dismissed the
Wow.
charges. Well, it's kind of handy, you know, when a judge can handle both sides of the case and earn money, handling two different opposing sides, working what we call working both sides of the street. I would call that a chummy arrangement. It has
Well,
nothing to do with justice, but
And it has nothing to do with integrity, I would say, either.
No, that's right.
But when you have a Judicial Qualifications Commission that does not have a clear-cut standard of what is integrity and what is not integrity, and is headed by a bunch of the judicial cohorts, it's no surprise. Like, again, like me, it says that we see no resulting penalties from their behavior.
Now, question, on July 1st, coming up pretty quickly will be the reinstituted organization to look into the ethics of attorneys and judges. Would you keep track of what's going on there and show
Well,
and
the
tell us precisely how this marvelous change
the,
will
the Board of Ethics, I hate to interrupt you, but the Board of
Sure.
Ethics was basically allowed to probe into attorneys and prosecutors' actions. It holds no authority to do so in the case of judges.
Oh, okay.
As to what I was made to understand. So, again, we've got people that have no checks and balances. The judiciary is definitely, especially in this state, without any sort of adequate checks and balances to check their behavior and their actions or inactions.
So they have open range?
Yeah, they got it's open season from the judiciary. Believe
Okay.
me, believe me, it is
Open
open
range,
season.
open season on the people, but open range as far as their movement is concerned. There's no fences or anything.
Exactly.
Okay.
Now,
Now on
one-
July 4th, something else is going to come about, and that is felons will get their voting rights
Right.
restored. Do you have a comment about felons actually voting once again?
Yeah, I do. I think that's. I think I second what the governor said in regards to that, which was, these are people that have paid their debt to society, and we can't continue to basically segment them from society. We've got to have them come back in to be productive and participating members of society, and one of the ways we can do that is to restore their voting rights. And I think that's commendable because a lot of the politicians this day and age are so tough on crime that they can't see themselves making a comment such as that and doing something such as restoring felons' rights. The old way obviously is going out. I guess it's not in fashion anymore to be so tough on crime to just deny people a second chance.
Right.
I guess that's going out of fashion to be that way. But that's a good thing. I think we should commend the governor on that. That's one of the
Absolutely.
good things that he's done.
Very few things that we can commend him on, but
Yeah.
on restoration, I think when you find one, I think you've good way to go, Gov.
Yeah, well, that's a good one. had a
I got
couple-
the opinion that John Michelson didn't think much of that idea this morning. He talked about that.
If
He looked at it differently than we do.
yeah, well, it's always going to be a people that's going to have some sort of say so. But when one of their own is affected, I believe they will
Right.
change their mind quite quickly.
That's true.
We had another commentator, very famous one, Rush Limbaugh, who was tough on drugs, tough on this and tough on that. Look what happened to him.
That's right.
So it's come full circle
Right.
when it came back home to him. He was such an advocate of tough crime on drugs and tough on this, and people don't have right to privacy. Well, he was the main advocate in his case for the right to privacy when they were subpoenaing his medical records. He backtracked and started saying that there is a right to privacy after he had initially said there is no right to privacy.
Right.
So
Some
we'll see.
people learn the hard way.
Yeah, some people learn more when it happens to them. They see the wisdom of what's transpiring. A couple quick cases I wanted to go over. One was in the St. Petersburg Times. This was in Florida. This was a lapse in judgment from June 19th, 2005. It's an editorial. No institution did more in recent years to clean up Hillsborough County's judiciary than the State Judicial Qualifications Commission. But the agency tarnished its legacy by prosecuting Hillsborough Circuit Judge Gregory Holder on dubious charges of plagiarism. 2 years of investigative work produced a dearth of evidence, yet the JCQ continue to fritter away its resources, Holder's money, and the elected judge's reputation on, at best, an uncorroborated circumstantial case. And I'll just paraphrase this. They basically, what they did is they went after him, acting on a tipster's word that alleged that as an Air Force reservist, Holder cribbed a paper for a military course. Now, regardless, this article goes on to say, regardless of whether this case was a payback for Holder cooperating with the federal probe of courthouse corruption, the Judicial Qualifications Commission reversed the presumption of innocence by bringing forth a flimsy case. The 6-member commission panel that heard the case is expected to rule within weeks whether Holder should be reprimanded or even removed from the bench. Now, this is really crazy because here we have a judge that's not even being held to any sort of integrity for his actions in office, but supposedly for a cheating on an exam or cheating on a paper. Sounds fishy to me. And it sounds familiar to me, though, at the same time, because we've had judges. There's one judge that has a website, matter of fact, Doug Schaefer, out of Washington State. Doug Schaefer has a website. It's www.dougschaefer.com or .org, I believe, one of those. And he spells out what precisely happened to him from a similar judicial commission in his state. What these commissions tend to do in a lot of instances, instead of protecting the citizens, they protect the interest of the elite and ruling class judges. That is, they'll go in, and if an allegation is made against a judge from another judge, that judge will be facing payback. And this is just one instance of that. And if you go to www.dougschaefer.com or dougschaefer.org, you will also see another incident of it. I think that the Judicial Qualification Commission should be there to protect the citizenry. However, in case again, just as this case is a recent case, we see that it's not doing its job in protecting the citizenry. It's protecting the secular interest of the judges and their secretive and dirty ways. If the judge doesn't follow the credo, one hand washes the other, we see in a lot of instances that judge is facing retaliation from those same people that believe that within his own clique. But did you have comments on that, Don or John?
I think there is a brotherhood that...
it's a secret brotherhood, isn't it?
Right. You bet it is. And it's a very powerful and formidable one. We do need to give judges some slack, and we do need to give them some honor. We do need to uphold their office and look upon it with as one of dignity and integrity. But I think it also behooves the persons holding that office to earn that honor and integrity by doing their job and doing it correctly. That's my comment there, Terrance.
Yeah, and I think that in a lot of instances, the people or should not have to be faced with situations where they're supposed to be so humble and so fearful of these judges. You know, there's a lot of attorneys, and this pains me because, you know, we're supposed to live in a free society. There's a lot of attorneys that are so fearful of doing anything or saying anything that might offend a judge. You know, I understand that to a certain extent, but, you know, the judge is supposed to rule according to the law and the facts. You know, and it sort of feels to me like a lot of instances they feel that the judges will rule according to whether or not the judge is offended or not. It shouldn't be the way. If they have these high ethical standards, then the judges should follow them. They should be following the facts and the law, and disregard all of these other criteria. And a lot of attorneys will, a lot of instances I've heard that they will get less work referred to them by the judges in certain cases. And it shouldn't be that way. There's definitely a lack of integrity within the state as far as judges, and that's why I had the group called VJO, Vote Iowa Judges Out, and we are advocating that a lot of these criminals, and I do say criminals, because they're not going by any sort of standard whatsoever when they follow these canons. We should vote them out. But that's my piece on that. Did you have any other comments? I know you guys had to wrap up the show with a few other items.
We'll get some sound back here. Yes, there's one case that we had here in Iowa where there's been several cases, in fact 11 cases, where people have been killed by uniformed officers. And the uniformed officer says, well, he had a gun, or I thought he had a gun, or is his life or mine? And so therefore I decided that I would take his life. I have a high regard for the outcome of a jury process. But it kind of tears me up when I see the jury process up in Harlan, Iowa, where the jury was open to all kinds of pressures from downtown folks. Signs of supporting a defendant who in 5 seconds made some split-second decisions. Now, I'm not saying whether that's right or wrong because the jury said he's innocent, and I have a high regard for jury verdicts.
Well, was that involving that officer Chad Butler?
Right.
That killed that guy?
It looked to me like he already made his decision while he was driving down the road before he even jumped out of that police car in that last 5 seconds.
And the jury asked to see that tape over and over and over again, and it said that everything he did was right. I have a difficult time with that, taking something of that sort and piecing it together with what I saw of the crime myself.
Well, do you believe that the judges could have some role to play in that? Because I've seen a lot of cases involving officers. They're part of the brotherhood, too, in a lot of instances of the judiciary. And I've seen in cases where they come in, they make these jury instructions for, they could make them real hard or real easy to convict in a lot of instances. For instance, they could say, well, if the guy killed him and you guys are convicted of manslaughter, you have to point to a specific time in which you believe that the officer was not justified.
Right.
And
right.
you'll see those kind of instructions in cases that are involving one of their brotherhood. You won't see those kind of specific requirements of cases involving just an ordinary criminal defendant.
Where you have a criminal who carries a camera into a courthouse.
That's happened in a lot of cases, and and that's another reason why I say we should be voting these criminals out, these judges, that is, because they do things like that. There should be a uniform jury instruction in all cases that is implemented in all cases, not one that's just implemented in some of the cases and not in others. But they do this. They've done that in plenty of cases. They've done it in the more famous case of Rodney King.
Yeah, right.
They made some very specific requirements in that case as well, and you see what the outcome of that was.
You bet. Well, I think what we've been asking for the death penalty here in Iowa. There's been a number of get tough proponents that want to bring back the death penalty. Well, I must announce to you that we now have the death penalty in Iowa. It has certain requirements, of course. First of all, you have to be an officer. in order to kill somebody, and you have to do it on the spur of the moment, and you have to do it asserting your authority to do it. It has no requirement for any trials or any reviews or any post-conviction relief efforts. It requires no incarceration of the individual, and the high recommendation is the larger the caliber, the smaller the shorter the paperwork. So go after them. You've got almost certain immunity from prosecution now. This was the first case of this in 10 years, and the jury found him innocent. And I must applaud the jury because the jury apparently did its thing. I think it was heavily influenced, wrongly, but I have to applaud the jury for their verdict because I appreciate the process, the jury process. There was a woman that tried to clean up things in Texas, Don, and she happened to be a social worker. That's how she knew that things needed to be cleaned up. She ran into a few problems. Would you tell us a little bit about the lady in Texas that had some difficulty with Texas social services?
Well, she decided to write a book here, and I'm showing you the cover of the book. And if you look over here, not at me, I'm looking at the book, John. There's a doorknob here, you see, and the door is opened up here a little bit, and there's a picture of a child, young teenager, and there's a teardrop. You know, she's in the system, and DHS is controlling her and destroying her life. Anyway, here's the name of the worker, and she wrote this book and called Dark Secrets, and I'm going to turn the page here, and I'm going to show you a website. Okay. Down here at the bottom. So if anybody wants a little more information on that, you can go into the website. I guess I can't guarantee it's on there today. You know, they can put them on and remove them. So anyway, it's bcity.com/whisperingwords/. And I'm just going to close the book, John. But I want you to keep the camera on it.
What's that about, though? What's the book about, John? Or Don, I'm sorry.
She gives a story on, describes the inside of DHS and how it's affecting children. And I'm going to read the back side here, and I'll just pull it off here now, John, if you want to switch the camera at this time. And it says, "Who is protecting the children? We spend millions of dollars each year to combat child abuse. Children continue to die. We have thousands of organizations that are formed for abused children, yet the abuse continues. We all agree that child abuse should come to an end, so why does it continue? And why are many of the children who are killed known to have been previously involved with Child Protective Services? What has gone wrong with our means of protecting our children? Why does our system of justice seem to always fall short when it comes to the safety of our kids? In Dark Secrets within Child Protective Services, the book I'm referring to here now, we look at the problems that encompasses this controversial agency. We see how kids fall through the cracks and what happens when they do. We take a look through the eyes of a caseworker who witnesses enough tragedies that she feels she has to stand up and fight back. But the odds are stacked against her. One woman alone cannot fight a wealthy state agency by herself. In fact, she'll get fired. That's what happens to these workers. Final paragraph. But this woman who I think they left out a word here. But this is a woman who just doesn't give up. She believes in what she is fighting for. That is safety of our children, as well as the sanctity of our families. Thus, we unveil dark secrets within Child Protective Services. John?
Okay, you might see if there's a selection in there that we should consider. That it'd have to be fairly short because we're coming pretty close to the end of the program for this week. See what you can find in there.
Why
John.
don't we just go back and talk about the appeals?
Okay,
we
go
keep,
ahead.
Commenting about what happens when that social worker comes knocking on the door and says, we're here to investigate child abuse or a dirty house or no running water, different things. Sometimes it's all made up. Sometimes they just twist the truth. So I suggest you don't say a word. Put it in writing. Tell the social worker to send questions to you. But when you get to talking, you'll trip yourself up and give the social worker 10 pages of information to talk about. So be very careful in talking to that social worker. And then when the abuse report is founded, let's say it's founded or unfounded, get the information. Find out what the social worker put in writing. Ask for it. That'll come within 30 days of that first letter saying that they're going to investigate. Or if you haven't got a letter, maybe your children have been interviewed at school. Anything like this puts you on notice that DHS is out to find you guilty of child abuse. John?
There are a number of terror tactics that the DHS is engaging in now. That is, in any tactic in which they force you or intimidate you or tell you that you must do something or else they'll file juvenile court charges against you is totally ridiculous. For an example, I've had a number of people call me and say they want to remove my children. They told me that I would have to get a what we call a UA, that's a urinalysis, because they suspect that I've been using drugs of some sort. And I think if you have a private source where you can get a drug analysis, a UA, that would be one thing. But I certainly wouldn't take a urinalysis unless it is court ordered. I would not get a mental health examination unless it's court ordered. We should have a high regard and respect what the court order says. But until it is written, we should not take the word of the social worker. Just because the social worker can make your life miserable is not justification for doing things. Well, it's time to wrap up our program for this week. Thank you for stopping by Channel 15, and we promise to see you next week. Thank you for watching the CPI report.